Hey, good morning. Good morning. Good morning. Happy Sunday, fun day, everybody. Thank you so much for being here. I'm in a fantastic mood. I had a long weekend. We worked very hard. We actually went to a convention this weekend, the VidCon convention. I don't know if you guys are familiar with that, but it's all about people in the video media space, basically for people on YouTube. And it was all of us from Courtroom Confidential and then a bunch of 16-year-olds who have wild hair running around doing selfies of themselves. So we felt very, very comfortable, very, very much in our space. But it was a good time because we learned a lot and, a lot of stuff we hope to utilize in building this channel. But it was long days, but we're looking forward to this. We're really excited. We are juiced this morning. My name is Joshua Ritter. I am a former prosecutor. I was a district attorney in LA for 10 years. I left to become a criminal defense attorney, go into private practice. I've been doing that for nearly as long. This is Courtroom Confidential, where we do our best to give you a perspective from both sides of the courtroom, and we hope that we do that. Arizona gal, always first to kick us off. Appreciate you so much. Thank you so much. It says Joshua Ritter and mods, you rock. That's the message. I love it. Thank you very much, Arizona gal. And then I see I see one other person here. Oh, Joe Schmo. Thank you so much, my friend, for becoming a new member. I appreciate that. So hello to everybody who's in the chat. Afton and Shy Gal, I see you both here, and Farm Girl and Becky B and Crazy Mom RN. Thank you, everybody. Simone B for showing up on a Sunday. Please take a moment right now. This is one of the things we learned, to ask folks to like this video so we can let YouTube know that we're here. Subscribe if you haven't already. And if you have a moment, please share this video. Let other people know about it. Let other people know what we're doing on Sundays. Please don't let it be the best kept secret on YouTube. Okay, so here's the plan. We're going to go through our voice messages. We got a bunch of them. They're all fantastic. You guys came through. And then we are doing some announcements, and what you've all been waiting for, we're doing our big 35,000 subscriber giveaway. Simply Love from Belgium. Thank you so much for joining us. 35,000 subscriber giveaway. We have our winner. We're going to announce it at the end of the show, so please stick around. But without any further delay, let's jump into our messages, huh? Let's get this rolling. Did I get this set up? Of course I didn't get it set up. Here we go. All right. Here's how I stall while I get this set up. Incredible. The one job you had, Josh. All right, here we go.
Hi, Josh. This is Sandy from Ohio. I love all of your shows and hearing your perspectives on different cases and your stories. However, I do need to push back a little bit on what seemed like kind of a flip answer about working with psychics and mediums to help solve cases. Somebody I know said that the absence of evidence is not the evidence of absence. Just because police aren't advertising that they are involved with psychics and mediums doesn't mean that they aren't doing so. As we all know, information from a psychic or a medium would not be admissible in court, so the police would be using it as a tool, and likely it would be advertised as, if nothing else, as a tip, just like a tip that came from anywhere else, and not be used as, I solved this case. Thanks so much. Bye-bye.
Sandy, I love it. Kicking us off with put me in my place. Sandy, first of all, let's put you on the map. Calling from Ohio. There you are, kicking us off on this Sunday. Touche, Sandy. Touche. The absence of evidence is not the evidence of absence. What excellent advocacy to use your opponent's words against them. So I appreciate that. And you're absolutely right. Just because the police haven't come out and said we solved this case because a psychic helped us does not mean a psychic did not help them. And maybe they're just not letting us all know about that. I feel appropriately put in my place, Sandy, and I appreciate you calling in, and I appreciate you putting Ohio on the map. And you are, of course, entered to win the shirt, and I kind of hope that you do, given that I feel chastised. So thank you for that, Sandy. All right. Our next caller here.
Hey, Josh, this is Rufus from Barstow, California. How you doing? Long-time listener, first-time caller. I love your show. I love the way you talk fancy, but still kind of normal. I respect that. But you don't come off like one of them TV lawyers who's always yelling objection when no one even says nothing. That is classy, man. So listen, I got a quick question. Maybe it's a dumb one, but I don't believe in dumb questions, just dumb people who don't ask them. So anyway, I've been thinking I might like to be a lawyer. Not one of them Hollywood lawyers or anything, but just like a regular one, like helps folks with their land and their restraining orders. I can relate to that. Real practical law. You know, I got my GED back in 09. Took me 2 tries, but I got there. I seen a whole mess of courtroom TV shows, Judge Judy, Boston Legal, the one with the bald guy in suspenders. And I think I know the vibe. So here's the question. What's the best way for someone like me to get going? I mean, I hate looking to go to Harvard or whatever. That's Boston, I think. And I got a fear of clams. So that's a no-go. But maybe you know a good online law school or something more. I'd like to get it wrapped up in 4 to 6 weeks tops if I could. You know, they got some fast-track programs for real estate licenses and notaries and phlebotomists. I'd like to find something like that. Anyway, I hope you can help in that regard, Josh. Thanks for your help. This is Rufus and Barstow. Just kidding, Josh. Derek from Santa Barbara. Love your show. See you later.
I got to tell you, when I listened to this, I got all the way to the end, and I really wanted Rufus to be real, because Rufus, we love you. Rufus, already the callers this morning are cracking me up. Derek, our good friend from Santa Barbara, putting you on the map. Thank you again for calling in. That was very funny. But you reminded me. I don't even know if your question was serious. What does it take to become a lawyer? When should you start becoming a lawyer? When's the best way to become a lawyer? But it made me think of one of my favorite quotes. And so I thought I would share it with you guys again, because this is just something that a mantra, one of the mantras I live by. The best time to plant a tree was 20 years ago. The second best time is now. The idea is, hey, maybe you could have gotten started earlier. Believe me, every single person I talk to who is successful in this YouTube space started during the pandemic. It seems like we were the only people who didn't get the brilliant idea to start a YouTube channel during the pandemic. During the pandemic, I was too busy, I don't know what, hiding in my home. And we actually, I'll tell you what we were doing. We found out that we were pregnant with our very first beautiful daughter in February, and then the world shut down in March. So we spent the pandemic doing our announcements to all of our friends and family that we were having a baby over Zoom, if you can believe that. It was quite an experience. But the one side effect of all of that is that we have all of these announcements on video because we recorded them all. So anyhow, I know that's not what we were talking about. Rufus/Derek, thank you again for the call. And remember, Rufus, the best time to plant a tree was 20 years ago. The second best time is now. All right, let's keep it going here.
Hi, my name is Carrie from Cleveland, Ohio. Longtime listener, first-time caller. I had a question on the federal complaint against the Minneapolis shooter. This seems like a state case to me, since it wasn't any federal employees that were injured and it wasn't across state lines. Is this another Luigi case? Or is this simply the new normal, that any high-profile case can be made federal because interstate wires can be considered the use of internet and GPS? I'd love your thoughts, Josh. Thanks.
Carrie from Cleveland, Ohio. I got to tell you, when you started off with longtime listener, first-time caller, I thought we had another Rufus on our hands. But Carrie, you sound like you are a real person calling from Cleveland, Ohio. So we'll put that on the map. And this is about the Vance Boelter case. This is a really tragic case. And thank you so much, Carrie, for working up the courage to call us for the first time. And I hope you call again. This case, if you guys have not been following the news, not the true crime news, but the news, this was a really, really disturbing, sad, troubling case out of Minnesota. This took place just this month in June. This person here, Vance Boelter, took it upon himself to try to assassinate several politicians in Minnesota. First, he went to the home. How did this all work out? If I get the order of this incorrectly, forgive me, but he went to the home of Minnesota Senator John Hoffman first and his wife. He was disguised as a police officer, knocks on their door. They open the door thinking they're opening it for an officer, and he immediately fires shots inside of their home. It's awful. They, God bless, that is Senator Hoffman, Minnesota Senator Hoffman there on the right. Him and his wife blessedly survive. This maniac then quickly goes to the home of Minnesota Congresswoman Amarita Hartman, who is on the left there, along with her husband. Police now are aware that something is going on, and they have actually responded to her home. He fires inside of the home from outside, then goes inside and fires more shots, and both Congresswoman Hartman and her husband tragically die. He had plans, it sounds like, to kill other people. So incredibly horrific. I mean, definitely the elements of terrorism, everything else involved in this case. And Carrie's question, and this is a great one, is why is this a federal prosecution? What, and I understand the confusion. We're like, when do the feds get involved? When don't they get involved? This didn't involve, Carrie makes the point, this doesn't involve federal employees. This was a Minnesota state congresswoman and a Minnesota state senator. This didn't take place across state lines. So what, the question that Carrie is asking is what is invoking essentially federal jurisdiction here? Well, Carrie, excellent question, but I think you might be conflating, and I don't mean this, don't take offense by this at all, but I think you might be confusing the issues of jurisdiction when it comes to civil issues and criminal issues. Civilly, you're right. We're not talking about any sort of interstate commerce here. We're not talking about some reason why someone would have federal jurisdiction for a lawsuit. That might become another issue down the road. But we're talking about criminal jurisdiction. And we've talked about this before, the idea that the United States has this concept of dual sovereignty. There is there's the United States of America, that's our federal government. And then each state is their own government. Each state has their own laws. Each state has their own judicial system. And there's also a federal laws and federal judicial system, and they operate independently and sometimes concurrently with each other. And in certain situations, you will have what's called concurrent jurisdiction, which occurred in, as you point out, the Luigi Mangione case. There are some other cases where that have been invoked. But in this situation, the feds have decided to be the ones bringing charges. I think the reason for that is you're talking about political assassinations, you're talking about acts of terrorism, you're talking about elected officials who are the targets. These are all the things where you would expect for the federal government to get involved. This is the kind of thing that has ramifications and implications far outside of just the state of Minnesota. And so you can understand why the feds would choose to get involved here. But the answer is yes, it could have been filed on a state level. Yes, and it can still be. This is still a murder, two murders and two attempted murders within the state of Minnesota, and they have jurisdiction over that, but so does the federal government. These are still federal laws to kill someone, still a federal law to attempt to kill someone. So a lot of times there is this dual sovereignty, concurrent jurisdiction, and it will be up to those jurisdictions who gets involved. To kind of your greater question of when do the feds decide, it's kind of up to them. In certain situations, I just think that they feel that they need a presence, that they want, that there are ramifications outside of that state. Luigi Mangione, I think, is an act of terrorism that they wanted to make a statement on. This case in particular, you're dealing with, the ideas of terrorism and political assassinations. They want to be involved. And I don't know if there has been coordination between the state of Minnesota and the feds to say, hey, we're handling as the feds, you step back as Minnesota, or if Minnesota is still planning on doing something, or if they even have to necessarily coordinate with each other, which is another question. But really excellent point, Carrie, and really keen observation to bring that up. And I'm glad that you did so that we can further kind of understand that. So thank you. Carrie from Cleveland, Ohio, and Farm Girl, thank you so much for the gift of memberships. I appreciate that. 5 Courtroom Confidential memberships. Again, kicking us off. Appreciate you guys. Generosity, as always, really, really warms my heart to have your support. Okay, let's keep it going here. All right.
Hi, Josh. This is Fauna Estef up in Coeur d'Alene, Idaho again. My question is going to be expanding from Pam from Michigan from last Sunday. Her question had to do with the judge and Lori Daybell's tantrums in court. And you explained the Faretta right that clients have that go pro se. My question is, are there any other measures or tools that a judge can use in order to keep the court from going off the rails? Because I felt like between her, Daryl Brooks, and a few others that they are intentionally trying to disrupt the court, and there needs to be something a judge can do in order to keep things flowing. But what measures can they take, and to what extreme can they take them? So that's my question. Looking forward to hear the answer. We'll listen to you next Sunday. Thanks.
Fauna from Coeur d'Alene, Idaho. I love this question. I hope you are listening so that you can get an answer to it. If you are, please say hi in the chat to us all. Fauna, first of all, pat yourself on the back for knowing about Faretta rights. I love that you now understand this concept, and I hope that you have used it in casual conversation. You understand an issue that 90% of people don't understand, and I would say 60% of attorneys still don't quite understand the concept of. But yes, Faretta rights are the idea that we have a Sixth Amendment right to counsel. The founding fathers in the Constitution wrote in the concept of, we are not going to allow someone just to, if they cannot represent themselves, just to be hung out there to dry. So the founding fathers in their infinite wisdom said, listen, we're going to write into our Constitution the idea that you get counsel, that you are, even if you can't afford one, counsel will be appointed to you. We've heard this all many times. And our Supreme Court took a look at what that actually means in the case of Faretta versus California out of 1975. And they said something, I really love this quote. I've read it to you guys before, but I'll read it again. It says, to deny a man in the exercise of his free choice the right to dispense with some of these safeguards, these rights, is to imprison a man in his privileges and call it the Constitution. And I love that. Essentially what they're saying is, listen, just because you have a right from the Constitution does not mean that you can be shackled by that right. Does not mean that you can have that right foisted upon you if you do not want that right. To do that would be to imprison a person in their privileges and call it the Constitution. Just love that concept. So what they said is, essentially, you have a right, a constitutional right to an attorney, and you have a constitutional right not to have an attorney. So Lori Daybell invoked her constitutional right, if you want to call it that, to represent herself. And as far as what can a judge do if it starts to get out of hand is really your question, Fauna. What can you do? And I hope, did I miss putting fauna on the map in beautiful Coeur d'Alene, Idaho, by the way? I've been there before and I know that it's gorgeous. So there it is if I missed it. Forrest Nelson says, like, subscribe, share, comment. All those things help direct others to this stream. Thank you, Forrest Nelson, who in no way is a plant. And I appreciate you with the super sticker, and I appreciate you reminding everybody. So don't get out of line. Listen to Forrest. Anyhow, back to Lori Daybell and Fauna's question. The judge makes an inquiry as to whether or not she can represent herself. That inquiry is very limited, and that inquiry is not what I would call the highest of hurdles. Basically, the judge has to decide, is she waiving this right? And this goes for pretty much any right, but we're talking about Faretta rights here. Voluntarily, knowingly, and intelligently. Is she doing it of her own free will? Does she know exactly what she's doing? And does she reach the bare minimum of kind of intelligently understanding the undertaking in front of her? Does she understand what she's accused of? Does she understand the idea that witnesses are going to be presented and she has to cross-examine those people, and that she has to make an argument, and that there are rules of evidence, and these things that are, you know, not the uncomplicated concepts, but not the, you know, still simple to understand. Okay. If that has been done, and that's up to the discretion of the court, there's really not much a judge can do to unwind that, because if you think about it, you're talking about taking away somebody's constitutional rights. If the judge were to say, you know what, Lori, I'm done. You've given me way too many headaches. It's too early on a Monday. I am sick of her SHIT, and I am done with you. I'm appointing you counsel. I'm taking away your constitutional right to represent yourself, and I'm appointing counsel. The firestorm and fallout and appellate swamp that would create from that is not worth it. And that's why the judge won't do it. So yeah, she's going to make these challenges. She's going to cause a bunch of trouble. It's going to be a pain. It's going to take longer. It's going to be exasperating. But a judge really can't do it unless the judge feels that it's gone so far to the point that the criminal justice system has come to a grinding halt. We saw that a little bit. Oh, I do this every single time. Darrell Brooks? That was the case where he represented himself for the Christmas Day parade massacre. And the judge allowed him to represent himself, but had to remove him from the court a couple of times. That's probably the worst that you would see. But the idea of actually then saying you cannot represent yourself just creates too much of the legal term is dumpster fire. So thank you so much, Fauna, from Coeur d'Alene, Idaho. Great question. All right, let's keep it moving here. Not my fault. Not my fault. Technical difficulties, not my fault.
Hi, Josh. Dorothy from Wall Township, New Jersey. Could you please explain how Alan Jackson, who's an attorney in California, was allowed to participate in a trial in Massachusetts? Thank you for all you do.
Dorothy from Wall Township, New Jersey. I'll tell you another side effect about this show that I love is hearing where you guys live. When you say, you know, the exact town that you live in, are some places I've never heard of. Now, don't throw stones at me if Wall Township is well known in New Jersey. I've never been to New Jersey, so I apologize for that. But I just love that we're hearing about all these little cities and towns around the U.S. and around the world, and it just, I don't know, it just creates such a fantastic community, and I'm very appreciative for all of you. But Dorothy from Wall Township, New Jersey, we put you there on the map, asked the question. Really good, straightforward question. A lot of people may have missed this or not wondered about it, but Dorothy did. How is Alan Jackson, an LA attorney, allowed to put his butt on a plane and fly out to, there he is, fly out to Massachusetts and represent Karen Reed? How does that work? And what Dorothy is asking is, and though it's not in her question, but it's implied, is, hey, I thought you were admitted to the bar. We just talked about this. Each state has their own laws. Therefore, each state has their own bar. Each state has their own bar exam and their own way of admitting attorneys. How can you pass the bar and practice in California and then practice in Massachusetts if you haven't taken the bar there and been admitted to the bar? Well, there is this concept that you may have heard before called when an attorney is operating pro hoc vice. Lawyers don't like to speak English. We have a problem with it. We speak Latin wherever possible. Pro hoc vice means for this occasion. And it is a very commonly used, I don't know what you want to call it, apparatus, concept in the law. For attorneys practicing out of state. You can go to Massachusetts, sit for the Massachusetts State Bar. I don't know if there's requirements that you practice in Massachusetts or receive some schooling, but as long as you're eligible to sit for their bar, you can sit for their bar and become admitted. Some attorneys do get admitted in other jurisdictions where they commonly practice. Someone had pro hoc ceviche. I remember that too. But if you don't want to go through all of that and you're only going to a certain jurisdiction for a limited purpose, for one trial, one case, you practice under pro hoc vice. And what it is, it's granted for a specific case. You're not granted to generally practice. So he cannot now, put together somebody's will or handle somebody's divorce in Massachusetts, but he was pro hoc vice for the Karen Reed case. You have to bring in associate legal counsel, local counsel, who kind of signs on for you, says, I'm going to be on standby. It depends on the state. In some states, that person has to be actively involved. Yannetti was the local counsel here for who was pro hoc vice local counsel for Alan Jackson. So he kind of had to sign off on everything, vouch for Alan in a certain way. In other states, I've done it here in California, where attorneys from out of state will say, can you be my pro hoc in California? And you basically sign paperwork and you never have to show up at all. You're just saying, hey, I know this person. I vouch for this person. They can practice here in California for this limited purpose. But it's up to the judge. There's an application process, depending on the state, how rigorous that is. And it really comes down to it being up to the judge, which means that it can be easily denied. A judge can say, I don't see a reason for you to be here. I'm not going to allow you to practice here. A judge can say, you've done this too much. You've practiced pro hoc vice too much. It's time to actually get admitted to the bar out here. And it can be more easily removed. And you remember there was an issue early on before trial started this second time around where people wondered, was the judge kind of upset by some, issues with the ARCA experts? Would it come down to her removing Alan's pro hoc vice? She could not remove Yannetti because he's admitted, but it's a much easier standard, up to her discretion, to remove the pro hoc vice privileges of an attorney. But she did not do that, and I think that was the right thing to do. Afton brings up Betterow. I think he was denied his pro hoc in that case. But I think Afton is right. That came down to conflicts of interest more than the application of him for pro hoc. But anyhow, great question. Something that we all kind of breeze by sometimes and don't really think about, but Dorothy did, and I appreciate that. Dorothy from Wall Township, New Jersey.
Josh, this is Gina from Chapala, Mexico again. And my question for this week is, would you please explain the SLAPP law? I keep hearing the SLAPP law and the anti-SLAPP law in conjunction with the Lively Baldoni case, and how they can differ from state to state, such as they decided to do the Lively Baldoni case in New York because the SLAPP law there was not as rigorous as the one in California. But I'm not even sure what the SLAPP law is. Please explain it and how it applies. Thank you so much.
Gina, always love hearing from you from Chapala, Mexico. There's Chapala. One day we're going to have to get the story, Gina, of how you ended up in Chapala, Mexico. But Gina asked the question about anti-SLAPP laws. What I love about a lot of your questions is that you bring up stuff that we might not think about, that we just kind of take for granted. Oh, yeah, that's an anti-SLAPP case. Oh, yeah, sure, anti-SLAPP. And everybody just kind of nods their head in agreement and moves on. Well, Gina said, no, give me the answer to this. What the heck is an anti-SLAPP law? And she talks about, she heard it referenced in the Lively versus Baldoni case, which is still ongoing and still a hot mess. And I don't understand why these two wealthy, privileged celebrities can't just figure it out, write each other some checks and move on and start to make horrible movies again. But here we go, anti-SLAPP laws. Well, it's not SLAPP laws as much as it's anti-SLAPP laws that we're concerned with. SLAPP is an acronym for Strategic Lawsuits Against Public Participation. And I think that they put that long word together so that they could just come up with the acronym of SLAPP because it sounded better. But an anti-SLAPP law basically works against that. So it's a law designed to work against strategic lawsuits against public participation. What does that mean? It means it's designed to protect individuals from lawsuits intended to censor, intimidate, or silence them for exercising their First Amendment rights, specifically the rights to free speech and petition. Where you see it, though, is when it's a little guy suing a big guy. And I'm not even saying that's necessarily taking place here, but it can apply in the Baldoni Lively case. But you've got somebody suing somebody else saying you harmed me, you assaulted me, you injured me, you damaged me, whatever it is. And then you've got this well-funded defendant who comes after this person and cross complaints and countersues and throws these big white shoe law firms at them, billing at $1 gazillion an hour. And they've got all these people and they just crush the little person into the dirt with their countersuit. And so the idea is, hey, we don't want all of these Goliaths stomping out all these Davids. What are we going to do to stop that? Well, if you can show that if you can use the state's anti-SLAPP laws to show that the countersuit is merely retaliatory and not merit-based, the judge will shut it down. The judge will just dismiss that countersuit. So it's a way for the little guy to get their case off of the ground without getting buried under the lawyers of the other guy. Now, that means they're still going to have their defense and they're still going to fight, but they don't have that countersuit hanging over you for hundreds of millions of dollars that causes you to dismiss your claim or sue or settle really early on. And so what it does, though, is it is powerful. It allows the defendant argues that the lawsuit is based on protected speech or a petitioning activity that should be dismissed. It shifts the burden. So now the big guy has to explain exactly what they're doing, and there's a burden shifting on them. And it gives an automatic stay to the discovery. So the big guy can't come in there, countersue, and then ask for a gazillion different interrogatories and requests for documents and depositions and just bury somebody. It's a really interesting law. Some states have it stronger than others. And Gina makes the point, it was that part of the reason why they decided to sue in a different jurisdiction than another. California has very strong anti-SLAPP laws. New York, I don't think, has as strong as anti-SLAPP laws, and that might have been some of the reasoning behind the lawsuit. And you'll see this all the time. We call it forum shopping. If they can bring a lawsuit in a different forum that's more favorable to them, they will. Two rich toddlers having a tantrum, says Crazy Mom RN. I couldn't agree more. Like I said, come on, we're done. it was interesting and fun at first, and we heard a bunch of horrible text messages you guys sent back and forth to each other, but now we're all tired, and we would rather you just get back to making movies and frustrating us all that way instead. All right, thank you again, Gina from Chapala, Mexico.
Thank you, Josh, for always having a podcast for the true crime information on Kohberger's case. I live in the area, and it has been a wild ride. Thanks so much. I'm Tina Duclos.
Tina from Idaho. I'm assuming Idaho, because you said you live in the area of the Bryan Kohberger case. So we're going to put you on the map as Idaho. So thank you so much for calling in, and thank you for the kind words. The Bryan Kohberger case is obviously going to become a very huge case. We plan on following it very closely, doing a lot of coverage on it. I'm going to even try to go to Idaho and give some insights from up there. So thank you, Tina. Appreciate the kind words. And we will continue to pump out the coverage as best that we can. Thank you, Tina.
Hi, Courtroom Confidential. This is Sonia from Chicago. Happy Sunday Fun Day, everybody. So my question is about Karen Read. And I'm going to just stay focused because there's so much I want to ask. But specifically, so I say you're always right about stuff. So you always talk about how the jury likes to split the baby. And so I know that you don't agree with all of the, all of the interviews that Karen Read did. And you even said if there's a guilty, it's going to be due to the clips, which you're right. However, was this the big plan all along? Because they knew that, and then they were going to add the charge, and they knew that they couldn't use the reports, so they actually did the Dateline for that reason? I mean, could that be the big plan? I don't know. Or could you just be right and I'm just crazy? Anyway, that's my question. Thank you.
Sonia, you are such a sweetheart. Appreciate you so much. Sonia from Chicago. Karen, yeah. So Sonia's question is, could they have been playing 3D chess and realizing that Karen was not going to take the stand? I don't think. My sneaking suspicion is there was never a chance that Karen Read was actually going to take the stand. I really do not see that ever being part of the strategy. Like I said, I've known Alan for a long time. The other attorneys I don't know as well. I know Liza, I don't know Yannetti, and I don't know Alessi, but they also seem like they're very experienced, smart attorneys. And very experienced, smart attorneys are not going to put their client up on the stand unless there is no other alternative. It's got to be an absolute Hail Mary to do that. You've got to have an incredibly compelling reason, and none of that existed here. So I don't think she was ever going to take the stand. So Sonia's question is, knowing that, do they want to get her statements out there as a way to perhaps bait the prosecution into playing her statements so that her statements could be in front of the jury in a way? I don't think that that is true because, again, I feel that the statements, some of them were helpful, but some of them were not. I feel like the statements would have been far more carefully crafted had that been the case. Karen herself has said that she spoke to the media a lot because it was, quote unquote, her way of testifying. So in a way, yeah, you're right, Sonia. But I really think that she just made a decision and was like, I need to talk about this. And if somebody wants to interview me, I'm going to talk to them about it. And my attorneys may be counseling me otherwise, and that's great, but this is still my right to do it, and I'm going to go ahead and do it. Now, everything worked out, right? I mean, we're now in the, we're playing Monday morning quarterback on all of this. she's a free person, everything all worked out. You could say that every single move they made was strategically the most brilliant move on earth. I still think her statements were probably the worst evidence against her. And if there was a chance for the jurors to have convicted her, I think it would have been in large part because of those statements. And I thought, here we go. When they asked the question, what do we do with her statements? Can we use those as evidence? To me, it's just, it was got to be nerve-wracking for her attorneys when those were being played in court. Like, how do we handle this? But the jurors obviously did not have a problem with it. So great question, Sonia. I don't think we'll see a case like that again for a very long time, for many reasons, but for nothing else alone, to have a client who just did not seem to think there was a microphone she was not comfortable in front of, or a camera she would not go in front of, when she's got pending murder trials against her. It still kind of flabbergasts me to this day. All right, let's keep it going here.
Hi, Josh. This is Flora Paris calling. And my question is, given the amount of time many of us spent together in the chat of the Karen Reed verdict watch on Courtroom Confidential, are we now legally in a domestic partnership? As a follow-up, if we are in a legal domestic partnership, how much money are they entitled to? I'm not planning on contesting any claims. I just would like to know for my own financial planning. Okay, thanks so much.
So we've got Flora, and earlier we had Fauna. I don't know if you guys know each other, but you should get together. I love the coincidence of all of that. Flora, thank you so much for calling. I didn't hear if you put down your location, but you referenced our Courtroom Confidential live trials channel. Are we in a domestic partnership because of the amount of time that we spent together? I don't think so, but I wouldn't be surprised if you start seeing lawsuits from each other to try to get some of that time back. If you guys don't know, we started a brand new channel, a sister channel to all of this, called Courtroom Confidential Live Trials, which is where we're going to be. Flora, out Oceanside, California. Oh, I love Oceanside. Thank you so much, Flora. We will somehow put you on the map later on, but thank you for calling. Yeah, we didn't want to put all the live trials on the main channel, but we also didn't want to abandon you guys to the scary, scary mean streets of YouTube to watch the trials. So we put together Courtroom Confidential live trials, CC live trials. Check it out. We had really great response and feedback for watching the Karen Reed trial. That was our first kind of experiment, and we are going to follow more trials, which brings me to the kind of question from you guys. What do you want to see next? I think the James Craig case out of Colorado is coming up soon. That is the dentist who poisoned his wife. Maniac of a man. By the way, it looks like he tried more than once, finally was successful in poisoning his wife and mother of his several children to death, then gets into jail, decides he's not done, wants to plant evidence. That doesn't work out, so then he tries to plot to kill the lead investigator against him. This dentist sounds like a real treat. Sounds like a real walk in the park kind of a dude that he cannot continue to stop burying himself. So that trial, I believe, will be televised. We might be covering that, but we are definitely covering Bryan Kohberger. Like I said before, we're covering all of the hearings. We've already put up one of the videos. We'll be covering as much of that, and we will be day to day on the Bryan Kohberger channel. So please join us. If you haven't already subscribed to Courtroom Confidential live trials, please do set your notifications so you know about when that's coming up. And I try every now and then to peek my little head in, say hi, give my thoughts, and then jump back out so you guys can enjoy watching the trial. But thank you, Flora from Oceanside, for the question. And yes, the summons will be arriving soon, Flora. All right.
Hey, Josh, it's your Ohio farm girl. Hey, random law question. If somebody pulls onto your property and you ask them to leave and they don't, is that when it switches to trespassing? What got me thinking about this is a true story. I was home on the farm by myself and car pulled up the driveway. Mom, dad, and a couple kids got out of the car and kids went flying into the barns. I go flying down to the barn from the house to see what in the world was going on. Dad tells me that um, his family had owned our property years and years ago, and he thought that they were just going to walk our farm. I told him no, they weren't, that they needed to go because, we had cows in the field and a bull in the field and yada yada. Took some convincing, but he finally decided that maybe they better go. And they left without any incident. But it just got me thinking, at the moment that I asked them to leave and they didn't, did that mean that they were trespassing at that point? Thanks. Bye-bye.
Farm girl from Ohio. I love farm girl because farm girl's a farm girl. Like, I love that you did not mess around with your name. You sounds like you live on a farm and you are a farm girl. This is an incredible little story that you put together for us. Thank you for that. I imagine that as you're having this, I don't want to call it, it doesn't sound like it's as much of a conversation as it is a strongly worded or a confrontation as much as it is a strongly worded conversation that you had with this man and his family. But somehow when I'm picturing this story, you've got a 6-shooter strapped to your hip as you're telling him that he probably should pack up and get on down the road. But you want to know what is trespassing. You ask a lawyer to define something for you, and the first thing they're going to do is go to the jury instructions, and that's exactly what I did. I feel like I wake up in the morning and I need to consult the jury instructions for how to brush my teeth. That's just how the world works when you're a criminal defense attorney. And here is the jury instruction, at least from California, about trespassing. And what I love about this is it will give you guys an idea of just how confusing and overworded some of these jury instructions are. So here are the elements. The people must prove that 1, the defendant willfully entered, we'll just say land, belonging to someone else without the consent of the owner. And that person is, and the owner who is in lawful possession of the property. So yes, farm girl, this person came on willfully. They entered your land and you own the land. 2, the defendant entered the land without consent. So they entered your land willfully and without your consent, and you had lawful possession of your own land. And 3, the defendant occupied some part of that land continuously until removed. So that gentleman stood there, would not go until removed by, I guess, your stern stare that you gave him. So yeah, that person was trespassing according to the law. But could you file charges? Would you file charges? Would the police actually file charges? Likely no, because it all ended in a very friendly way. And he made his way down the road. And I doubt anybody would want to lock him up for that. But the answer is, yeah, that person is trespassing. You have a right to be somewhere. Somebody enters willfully without permission. That person is trespassing. The only interesting part about this, I guess, is the willfully. Could somebody stumble onto your property on accident and not be trespassing? I suppose they could, and that's why they wrote the law that way. But farm girl from Ohio, don't cross her. I hope you got big signs up, farm girl. Do not mess with farm girl, because she's got cows and a bull in the pasture. She's not going to play with your shenanigans in business. All right, let's keep it going here.
Hi, Joshua. My name's Katrina, and I'm in Reagan, Tennessee. And I have some thoughts on the Kohberger case. So in the Kohberger case, the defense attorney argued for considerations because of an autism diagnosis to take the death penalty off the table. my question is sort of like, if the jury can use their observations as part of their considerations, it seems that they should know that the defendant has Asperger's or autism spectrum disorder and that his mannerisms are outside the norm. I think the judge ruled against this, but I'm wondering if it was a mistake by the attorney. I do not think it was the right argument. I don't think it should be for special consideration for a no death penalty. I think it should have been an instruction that observations of this defendant may not be used in consideration because of social inadequacies should be given. I do think he's fit to stand trial and that the consequences are what they are, and we'll see what all the evidence is. But I have also seen how he appears in the press, and his autistic traits are evident in that, and I don't think they should be used against him. So my question is, did she make the wrong argument when she argued for the no death penalty? Should she rather have argued for an instruction in order for their observations not to be used against him? All right. Thank you so much. I'm loving your show.
Thank you so much, Katrina from Reagan, Tennessee. Let's put you on the map again. Never heard of Reagan, Tennessee, so I appreciate you calling in for the first time there. Reagan, or pardon me, Katrina, not Reagan. Katrina asked a wonderful question about Bryan Kohberger. Did Ann Taylor make the wrong argument about his autism diagnosis? Should she have used that for a different argument? And Katrina, this is such a wonderful question. And it had me I had trouble answering it. But Katrina, as you know, I may be stumped, but I am never beaten because I can always phone a friend.
Hey, Katrina. Good morning from Josh and Justice Kitty. That's an absolutely fantastic question. Bryan Kohberger's mental health is going to play an outsized role in his defense. The state needs to make sure that nothing Bryan Kohberger claims disqualifies him for the application of the death penalty or other severe criminal punishments, and that's going to be using the state's own mental health rules. At the same time, the defense knows that mental health is a powerful tool. It engenders jurors to defendants. If you can humanize the defendant, it's very difficult for the jurors to enact the ultimate punishment with someone that they feel sorry for or that they feel isn't acting under their own choices. How it actually interacts with his behavior in court, we'll have to see exactly what happens. The judge has a lot of discretion to determine and explain how individuals in the court process runs, and we'll have to watch Bryan Kohberger's personal actions during the trial to see if he does anything that requires explanation. Can't wait to watch this one play out. The appeals contest is really where the big work's going to get done.
That was Josh Schiffer coming in from the wings to help us out and answer this question. Big thanks to Josh. He is, I feel like when God was making everyone, he's given out doses of style and character, and everybody's getting a little bit of a dash of each. And then he got to Josh and accidentally dumped a bucket full of character and style when he was creating Josh Schiffer. He's like nobody else. He's a good friend and he's fantastic. And I appreciate him taking the time along with his kitty to answer that question this morning. If you guys can give Josh a thanks on Twitter at his handle is Lawyer Schiff, SCHIFF on X. Oh, there's the tag for it. And just tell him big thanks from Courtroom Confidential. Thank you for answering the question. He's a fantastic guy. And that kind of is the answer here is that it is an important issue. It is an issue that was raised by Ann Taylor, Katrina. Yes, they argued it. Yes, the judge said he's going to allow it as a something to be brought up during the penalty phase if we get there, meaning if he's convicted, found guilty, and now we go to a penalty phase to decide whether or not he'll receive the death penalty, talking about Bryan Kohberger. But interestingly, Katrina, this issue was brought up. There was an argument made that they want the jury to know about it now to understand his kind of behavior and demeanor. It's interesting. I was looking for a picture of Bryan Kohberger to try to find some, reaction shot from him. Every single picture I can find of this man online that has been taken of him in court, he's got the exact same expression on his face. And I would describe that expression as expressionless. There is something unique, if you want to call it, different, bizarre, odd, whatever you want to characterize it about his demeanor. It is very nonplussed. It's funny. We went through, weeks of Karen Reed, who's a very visually responsive person. You can tell a lot about what she's thinking and how she's reacting to things by her face, and even micro gestures to flat out, looks of disgust or shock. This person, none of that. To the point that it's hard to find a photograph of him online where there's even a smile or a grimace. I mean, it's just, he looks like he's taking his mugshot in every single photo. And so Katrina's point is, does that need to be explained to the jury? Well, that argument was argued by his defense. And Judge Hippler, who I love, his response to that was interesting, and I think probably right. He said, to allow this issue essentially invites the jury to consider his character to determine his guilt. In other words, if what you're trying to do is say, don't consider his character, it's going to draw attention to it. He goes on, if anything, presenting evidence of the defendant's autism will focus the jurors even more on the defendant's behaviors than they likely would not have noticed in the first place. I think that's an excellent point. It's like, telling people, please don't pay attention to the man in the back of the room. You say that to them and everybody's going to look to the man in the back of the room. You ever been having dinner with somebody at a restaurant and you say, don't look now? And the first thing they do is go, where? They start looking around. That's exactly what he's saying these jurors will do. If you say, don't pay attention to his behavior, he's got autism, and this is how he behaves, that's all they're going to think about all day long. I think that's an excellent point. If they were not instructed on that, he would just kind of drift into the furniture and the background of the courtroom, and they're probably not going to pay much attention to his behavior at all. So anyhow, Katrina, great question. Hope you got your answer, but the answer is from the judge. It's not going to be an issue during trial, but it can become an issue during the penalty phase. And once again, big thanks to our friend Josh Schiffer. He's a great guy and quite a character, and has the best eyeglasses on television. And please go give him a big thanks over at his Twitter at LawSchiff on X. All right, let's keep it going here.
Hi, Josh. This is Christine from Langley, British Columbia. I just have two questions. The first one is, now that the Karen Reed trial is over, do you think you'd be able to invite Alan Jackson for a conversations evening? I think that would be a really fascinating conversation, and lots of questions, obviously, about the trial, but also I would love to know more about his background and his experiences. And the second question is in regards to your days as a prosecutor. Were you ever in a position where midway through a trial, the defense was putting on whatever evidence they had, convinced you that the defendant was actually innocent and that you had to now withdraw the charges? Just wondering the frequency with which that happens, or if you know if that has happened to anybody else, any other prosecutors. Anyway, thank you so much for your time, and have a great afternoon.
Christine from Langley, BC, Canada. We're going to put you on the map, our friends up north. Oh, that's where Langley is. Huh. I got to travel more. Do you know how difficult it is, even the thought of putting 3 little kids on an airplane and traveling somewhere? We used to travel so much. I hope it'll happen again. and I hope Tiffany's listening. But for right now, Langley will just have to remain on our wish list. But thank you, Christine. First, will I invite AJ on to be interviewed? I will happily do it. I will tell you this. AJ doesn't like doing these types of things. I imagine he will tell me, no. But if there's a way to do it, I'll make it happen. It's just kind of not his bag. He'll do, the Today Show or Good Morning America, but I don't know if Courtroom Confidential will fall on his radar. But he's a great dude, and I'll try to bug him as much as I can. But to your second question, was I ever in the middle? This is a great question. Was I ever in the middle of trial convinced of the defendant's innocence, and what did I do about it? And I thought long and hard about this, Christine. First of all, not to chicken out on this, but no. And that is because I probably more aggressively than others, if I felt that I had a bad case, would tell my bosses, this is hot garbage. We should not take this to trial. We need to plead this out. Or if I had questions about the guilt of the defendant beforehand, I would certainly bring those up. And I did. But did anything ever happen in the middle of trial where I thought to myself, this person did not do this? And I never came across that situation. I came across situations where my case was falling apart, but falling apart in ways different than I questioned whether or not we had the right person or whether or not there was a crime committed. But I asked my friends. I still have many, many friends who are either still in the DA's office or were in the DA's office and now are in private practice. And I said, you ever come across this? And they said, no, they didn't. My one friend who got close enough said he did have a case where he was glad that the defense won. And I don't think he would go as far as saying that he felt that the defendant was innocent, but he was not hurt by the fact that the defense won on that case. If you feel, the answer to this and why you're probably not going to get somebody to say, that they did, is if you felt that way, your obligation as a prosecutor is to stop. That's the whole thing about being a prosecutor. This isn't a purely adversarial situation. The defense is tasked with defending their client zealously, no matter what, within the bounds of the law. But there is no deciding, I don't want to do this anymore for my own reasons. Your job is tasked with defending that person. And that's why when I get questions asked about, like, well, what if you think that they're guilty? That's not my job. My job is to defend this person, even if they are guilty. They need a defense. They need to make sure that the system and the government's not going to just bulldoze them over. But as the prosecutor, you wear two hats to some extent. If you feel that justice is not being done, you are the only one in a position and should do something. And so, if I ever run across that, and I hope that any of my friends who are still prosecutors or any of them who had run across that, they would say, we need to stop. I need to talk to my supervisor. We need to figure out what to do about this. And maybe that's offering the defendant a plea deal to something lesser because what they're charged with is not the right thing. Or maybe that's even just dismissing it outright. And I'm sure that has happened, but I couldn't give you a great example before we went live on this. Court Junkie KDR, thank you so much, says, first, I agree with AJ. You and Alan make a dream team. Second, I believe that having 3 teenagers traveling is more challenging. Oh, don't tell me that. You're telling me it's going to get worse, Court Junkie? When do we get to travel? When they move out of the house? Oh, maybe you're right. Maybe when I can buckle them all in. But when they become teenagers and are yelling they already yell at me. They already yell at me now. I can't imagine when they're teenagers. It was so funny. I came home. I told you we were at this VidCon all day, and I came home on Friday, I think it was. I hadn't seen the girls all day long, and I walk into the room where they're playing, and our 2-year-old, doesn't run up, doesn't say daddy, doesn't say, you know, give me a big hug. She just stares me square in the eyes and says, fruit. she wanted a snack, and her butler had finally showed up. Where had he been all day? So that was the way I got greeted. I did get hugs and misused later on, but first I had to get to the business of providing them with snacks. Anyhow, thank you, Christine, so much. Thank you, Court Junkie, for the super chat. Appreciate you guys. All right, let's keep it going here.
Hi, Josh and crew. This is Jerry Michael from Newport News, Virginia. My question is related to the Karen Reed case and the Commonwealth team. How do you think Hank Brennan feels after losing the case, basically, to the defense? Do you think he was allowed to go back and talk to the jury and find out how they weighed all the evidence and came up with the verdict that they came up with? And then is he able to share that information with the team and kind of go over what we should have done differently, or what we could have done differently, or maybe not done anything differently? And then how do you think that this is going to affect them going forward as far as how they prosecute future cases? Of course, this one was unique, and I'm sure they'll never run into another one like this again. But Lowley obviously needs a little help in his ability to present the case, and I'm sure Hank Brennan would be able to give him some pointers. Thank you. Have a great day. Bye.
Jerry from Newport News, Virginia. Thank you so much. Newport News, had not heard of that before. A while back we had a caller who was from, was it Horseheads, New York? Is that where it was from? I remember that somebody, I think it was Horseheads, and gave us like the whole background of what the name of that, where that name came from. I'd love to know where a name of a city like Newport News comes from. But thank you so much, Jerry, for calling in. We're talking about the Karen Reed case. We're talking about Hank Brennan, and how does he feel now? Hank don't feel great. I will say that. This was one of those cases that you are on about the biggest platform, nationally televised, nationally covered. I mean, the verdict on this came out, and every national news did a story on it. Not the kind of case that you want to lose on. I think he feels exhausted. I think he feels beat up. I think he feels not great. Now, you asked the question of, did he go back and talk to the jury? Probably not. And here's the reason why. Or did he go back and analyze and dissect and figure out what went wrong, and what could they have done different? Probably not. Here's the thing. As a prosecutor, there's nothing you can do about it. As the defense, somebody's convicted, yeah, you're talking to the jury. You want to know, what were they talking about? Did they talk about anything inappropriate? Is there an appellate issue we can bring up here? You're going back and you're trying to analyze, is there any issues on appeal with your team? What can we do about this? How can this be undone? Hank doesn't get to appeal this. This is done. This woman is a free woman. Jeopardy has attached. They can never try her again for this. And life is going to move on. So I doubt that there was much of an autopsy done of this entire case. I'm sure that him and his team sat back and poured back a few cocktails and commiserated, but I doubt that there was much kind of talk about what could we do different, because they're never going to have that chance. Now, there was one last point you said, will they look at this in the way of how can they handle cases moving forward differently? Well, I think certainly from the investigative perspective, from the police perspective, they are looking at things differently and handling things differently. And I think you're going to see a lot of shakeup in that police department. In the Canton Police Department is definitely going through some growing pains in how they handle cases. And I'm sure that there are going to be many more protocols and guidelines as far as text conversations regarding cases, the preservation of evidence, the closing down of a crime scene, the collection of evidence, everything else that was made, into quite a spectacle in this case. I'm sure they're going to analyze. But from the prosecutor's perspective, they got the case that they had. I mean, that's the other thing too, is you got to really do your best to kind of distinguish between what the cops did and what the prosecutors did. I've been a prosecutor and been handed garbage cases by law enforcement before, and I didn't do any of that. I just got this garbage case handed to me, and I had to do the best that I could with what I had. So they work as a team, but many times, the left hand doesn't have any control over what the right hand is doing. But yeah, poor Hank. Hank's I hope Hank's having a pina colada on a sunny beach somewhere and trying to put it all behind him. Anyhow, thank you so much, Jerry from Newport News, Virginia. Appreciate the comment or the question.
Hi, CC crew, Mama Tiff, Caitlin. This is Subi Sue from Reno. First off, congratulations to Karen Reed. I'm so glad justice was served. But my question is on the Diddy case with Jane. Now, can the prosecution have a, what do you call it? What's the word I'm looking for? An expert come and testify as to what SA victims do, and would you do that as a prosecutor? And what are the ramifications of the defense getting a hold of that expert? So that's my question. And another quick question is, what makes people think that murder is an option instead of divorce? I'm just asking. Okay, I love this channel. I tell everyone I know to get online and subscribe. So thank you so much. And I hope you're able to keep going. Love you guys.
Subi Sue, thank you so much. I appreciate all the kind words and encouragement. Calling from Reno, Nevada. Let's put you on the map. Always appreciate hearing from you. Yes, there are other alternatives to a bad marriage other than murder. If you need help, feel free to reach out. But yeah, it is amazing to me. It doesn't go lost on me, the amount of cases that we see with married people killing their partner because they just feel like there's no alternative for them. It's pretty incredible. And yet, despite the incredibly slim chances of getting away with it, everybody thinks that they're somehow going to pull it off. But anyhow, we just had a brand new case with Morphew just broke over the weekend, where he's now going to be on trial for his wife's murder. So yeah, just a never-ending supply in this true crime world we all exist in of spouses killing each other. Got to get that life insurance, says Marley Mom. Yeah, check the fine print before you do anything crazy. Anyhow, back to Subi Sue's question about the Sean Diddy Combs case and the use of experts, especially in regards to sexual abuse. And you asked the question, could the prosecution call someone? And the answer is yes, they could. And in fact, they did. They called a woman by the name of Dawn Hughes. Does she look familiar to you? She should. She testified a few times, actually, in the Johnny Depp v. Amber Heard case. She was a person called as an expert to talk about the idea of the cycle of abuse and how that all works. So she was called as a prosecution expert in the Sean Combs case. She's got quite the resume. She has been called in quite a few cases. She was do you remember I don't know if we actually pronounce this or just say the letters, the NXIVM case with founder Keith Raniere. That was a big SA case she was an expert in that case. R. Kelly, she was an expert in that case. As I said already, Johnny Depp and Amber Heard. She gets called into these high-profile cases. She charges a lot of money. She's really high profile to talk about the complicated psychological issues in cycles of abuse. Now, what's interesting is in this case, the Sean Combs case, and in other cases, and you will see this sometimes, she gets called as what's called a blind expert. In other words, she doesn't know the circumstances of the case, supposedly. She's not being called to answer the question, do the victims in this case appear as though someone who suffered from abuse? And the reason for that is twofold. She was not a fan favorite in the Depp trial. That is true. But the reason for that is twofold. One, that would get close to answering that ultimate question for the jury. Was this person a victim of abuse? Calling an expert to say, I've analyzed it and I do feel that they were an expert for a victim of abuse would be substituting their expert opinion for the opinion that the jury should arrive at. That's one reason. The other reason is that if you do have an expert who's testifying to the facts and circumstances of that particular case, they can get cross-examined on all of that, all of the things they didn't consider, all of the, you could use that expert as a kind of backdoor mechanism to get in front of the jury a bunch of stuff that maybe would not have been admissible. So sometimes the smart way to play it is to just say, I'm not calling you to talk about this case in particular, but to talk about the cycle of abuse generally. Things like financial dependence, how it's common to stay in relationships if you're a victim of abuse, how shame, humiliation, degradation can be used as tools to manipulate and control another, the concept of the abuse dynamic, the concept of the cycle of violence, all of these things. And if you're a skilled prosecutor, you're weaving into these questions the facts that the jurors have already heard, so that the jurors can do the work of applying that expert opinion to the facts of the case, which they should be doing anyways. The other part of your question, Subi Sue, was what does the defense do then? How does the defense handle this person? How effective can they be on cross? In this case, in the Sean Combs case, they made a big deal about her resume. Isn't it in fact true? You have never testified in the defense of a man accused of SA. Isn't that true? Your entire history, you make 60% of your income from testifying, but you've never, ever testified on behalf of a man accused of sexual abuse. No, I have not. And so they tried to point out her bias. They tried to point out how much she's getting paid, kind of just par for the course cross-examination of an expert. But that's how they handled it. But they were not, most specifically because she was testifying as a blind expert, allowed to get into with her things that the defense may have wanted to get in front of the jury to ask about things that she did or did not consider, the things that may have not had an opportunity, a door open to them otherwise. So all sorts of behind the scenes strategic issues that good attorneys are thinking about. But thank you so much, Subi Sue. I believe it's pronounced Nexium. Okay. I think you might be right. Nexium. N-X-I-V-M. Nexium. The Nexium. The V is a U. Gotcha. Thank you, Kimberly from NYC. All right. Now that we cleared that up.
Hi, Josh. This is Maureen in Monterey again. I already left you a message about a case, but I just heard about an interesting case that I thought maybe you could address briefly if you have the time. If not, it's okay. But this case involves a firefighter from Dublin, Ireland, who has been accused of raping a woman in her hotel room in Boston. This is another case out of Boston. And I don't really know anything about it. No, I don't know much about it, except that I think the trial is over and the jury is deliberating and has been for 2 or 3 days. I'm not sure
I don't think they are deliberating today, Thursday, but they'll be back in court tomorrow. So by the time you get this message, they may have rendered a verdict, and this may be old news. But I just thought it might be interesting to discuss this case briefly because you have quite a few international subscribers, including subscribers from Ireland. I'm thinking right now of the wonderful Black Widow, who's a faithful subscriber. And I was just thinking that maybe they might be interested in hearing your take on this case. Thanks a lot, Josh.
Thank you, Maureen from Monterey. Appreciate the call. Let's put you on the map. I always love hearing from you. And yes, a shout out to our followers from Ireland, including Black Widow. This is a case that we have not given enough attention to. And you are right, Maureen. They have concluded the case, but it was declared a mistrial because the jury was deadlocked. The DA has already said that they intend to retry the case, so we will try to follow it more closely the next time around. But here are the briefest of facts surrounding it. He is from Dublin, Ireland. He is a firefighter here in Massachusetts, and he was accused of rape. It took place in March of 2024 on St. Patrick's Day, or around that time, at the Omni Park House Hotel in Boston. And his accuser is a 29-year-old lawyer that I kind of found interesting. And she is saying that after a night of revelry, she met Terence along with Terence's hotel mate, and that they went back to the hotel, that she consensually had sex with Terence's hotel mate, but then later in the evening, she was awakened to Terence Crosbie assaulting her, and that she woke up as it was happening. He brought allegations. He was arrested. We had an entire trial. A lot of it came down to issues of, her levels of intoxication, the lack of a kind of an eyewitness. DNA was an issue, but there was also the idea that, she had, I don't want to get too graphic about it, but that she had DNA from another individual, that she had been in Terence's bed, and that might explain some of the DNA. So I don't know enough of the details to really give you a good analysis of the strengths and weaknesses of this case. All I can tell you is that the jury could not reach a decision. It was deadlocked. It will be going back on a retrial, and we will continue to follow it. So that is the Terence Crosbie case, Crosbie, out of Massachusetts, involving this man here who was a firefighter from Dublin. So thank you, Maureen, for bringing up that case to all those of us who had not been that aware of it, and we will continue to follow that one. You guys enjoying this? Are we doing this at a good enough pace? Are you getting the answers to your questions? I hope so. I'm having a good time. I'm juiced. I'm happy.
Hi, Josh. My name is Amelia. I'm calling from Plainfield, Vermont. I really enjoy your show, and thank you for what you're doing, and to the people behind the scenes. I've been super alone during this Karen Read trial. I'm an island unto myself. Please don't everyone tackle me in the comments. I love you, but I didn't watch the first trial. I followed the motion work in between the trials and watched the second trial. I felt that there was enough evidence to find her guilty of manslaughter. And I know I'm really kind of alone on that in many ways, but I just watched an interview with juror number 4, and it was interesting. He was making some comments regarding doubt and guilty versus not guilty, and he seemed to be collapsing reasonable doubt into no doubt, and talked about, well, if you're 99% sure that Karen Read was guilty, that's not enough. You have to be 100% sure. And, extrapolating that kind of thinking from a juror and a jury out to other cases, that really struck me as something a bit concerning. Maybe that's the success of the defense, that the jury felt this way, but do we really want juries thinking there has to be 100%? Where is reasonable doubt in there? Isn't that somewhere in there that needs to be considered? What's your take on this situation?
Amelia from Plainfield, Vermont. Thank you so much for calling in. And I appreciate you having, like you said, being on an island, having different views. I that is one of the things I am most proud of, this community that we have, I hope, curated and built a culture of, hey, you can disagree, you can see things differently. We're not going to shout at each other. We're gonna talk it through. We're gonna appreciate and encourage the disagreement and the debate on things. And listen, even the jurors in this case, in the Karen Read case, did not walk into that courtroom or to that deliberation room all agreeing. Even they themselves said some of them felt that she was guilty, and they talked it out, and they did the work that jurors are supposed to do, and they deliberated, and they talked back and forth with each other and talked about the evidence, and then they were all able to arrive at a decision. So Amelia, you got nothing to apologize for here. I appreciate you sharing your thoughts. And you do bring up something that we have heard from some of the jurors now. And some of the jurors, I will say, have said some things that are not fantastic. Oh, I like this. Full-Throated Motion says, you got to be 100% sure you can live with your verdict, but I agree there's no actual percentage for beyond a reasonable doubt that everyone agrees on. That is a great way of putting it, Full-Throated Motion. You got to be 100% sure you can live with it, but that doesn't mean that you will have to be 100% sure of guilt. I love that. That's a great way of putting it. I've never thought of before. And in fact, the concept is most very distinctly not 100%. 100% would be no doubt. You understand? The standard isn't beyond doubt. It's beyond a reasonable doubt. Why is there that qualifier in there? Right? We all in our constitutions and laws wrote in the word reasonable, because we know 100% would mean no doubt, and that is a nearly impossible standard. No doubt to me means I saw the crime take place in front of my face. Means I saw you pull the trigger in front of my face. That is obviously not what we're dealing with here. So we had the concept of reasonable doubt, which implies doubt, implies less than 100%. Juror number 4, I think, is who Amelia was referencing. Like I said, a few of these people have done some interviews, went on TMZ and made a comment to Harvey saying, and this is the quote, "Are you really sure?" Talking about other jurors and their concepts of whether or not Karen Read was guilty. Are you really sure? Are you 100% sure, or are you 99.9% sure? Well, if you're 99, we can't convict you. This is something that you've seen a lot of people run with, going, what in the world are these people thinking? I will tell you this. I am bothered by that. I am bothered by that. That is not the standard. Now, does that mean that what they did was wrong? No. Does that mean that maybe they misunderstood the standard? Perhaps. Do I wish this juror had not said that to cause everybody to lose their brains? Yes, I do. But what does it reveal? Well, perhaps he misspoke. Perhaps he doesn't quite mean exactly what he meant. No reasonable doubt is not 100%. The law, we've talked about this a lot. You cannot assign a percentage to it. I love the comment from earlier. Basically, what it means is, do you have an abiding conviction? Do you believe beyond a reasonable doubt? Not possible doubt, not imaginary doubt, but just beyond reasonable doubts. Reasonable. That's a reasonable doubt. That is a doubt that you have that is reasonable. You're qualifying the doubt that you have. Do you have doubts? Sure. Are they reasonable doubts? No, they're not. So therefore, you're beyond a reasonable doubt. But you have to be sure you can live with your verdict, as Full-Throated Motion brings out. And that's what we talk about when we say an abiding conviction in California. That means that you wake up tomorrow, you feel you made the right decision. You wake up in a week, you wake up in a month, you wake up in a year, you wake up in 10 years, you feel that you made the right decision. If you feel sitting here today that you cannot say that, then you have not gone beyond a reasonable doubt. So it's both the idea of what does the evidence present to you, how has that been proven to you, and how do you feel that you're just going to feel about it? It's a very amorphous, touchy-feely, cannot be defined concept, but I'll tell you what it's not 100%. And so I do hope that was not the standard that was applied. I don't think that it was, and I think that maybe this juror was just speaking off the cuff and not clear exactly on what they were saying. LVX9 says, I think we have to be careful to just take what the jurors are saying as verbatim and completely literal. They're not used to having their words dissected. I don't think he really meant 99.9%. I think you're probably right, L. I think you're probably right. This person was not on the stand. They were not under oath. They probably did not realize how much their words would be dissected. And I think a lot of that can be attributed to probably, turns of phrase. I think that it came down to the concept of, are you sure? And that is kind of a way of putting it. Are you sure? Or do you have a reasonable doubt? Anyhow, we could talk about this all day long. The attorneys have been talking about it since attorneys have been wearing white wigs. So we're never going to solve that problem quickly on a Sunday morning. But thank you so much, Amelia from Plainfield, for asking the wonderful question. All right, let's keep it going here.
Hey everybody, it's Sarcasm from Fort Bragg. I just stumbled across a trial, Connecticut versus Raul Valle or Valley. It's Victor Alpha Lima Lima Echo. Nobody can agree on a pronunciation. And it's been stupidly dubbed the Preppy Party Murder Trial because they obviously couldn't come up with anything better. But the kid was 16. I just personally think he was jumped. But if you claim self-defense, do you have to testify in your trial? I believe he was jumped because there was 4 that he stabbed, 1 fatally. And in the interviews, there was 2 or 3 others who admitted to being involved in the altercation as well. So we don't even really know how many people were involved. But I just need, if it's self-defense, do you have to take the stand? Or do you think that the defense could, prove their case, which they don't have a burden of proof, but you get what I'm saying, right? Okay. Have a great day, everyone.
Sarcasm from Fort Bragg, North Carolina. Thank you so much. I feel like you ran out of steam right at the end there, but I think this is a fantastic question, and I am very appreciative. You're asking about the Raul. You said Valle. You said Valle. I say Valle. I don't know if that's just because I'm reading a double L together and figure that's how it should be pronounced. But Raul is on trial out of Connecticut for the murder of a young man, 17-year-old man named Jimmy McGrath. Really sad case. You're right. Court TV has dubbed this the Preppy Party murder case. Whoever is the intern over at Court TV naming these things for them, I'd love to meet that person. Tiffany and I are always laughing at some of the stuff they come up with. It's always like the, bitter wife stabby murder trial, or they got to come up with some clever little hook on every single case. And they have to be running out of steam, or they're just, throwing darts at a pinwheel to figure it out. But anyhow, it's a sad case. Basically, I have not followed this one super closely, but these are the facts as I know them as I've researched them, that they were a bunch of young folks at a party, a house party. A fight breaks out, a physical fist fight breaks out over beer, because that's what you do when you're young and stupid, is you fight over beer. Later on that same day, another fight breaks out, and in the middle of this fight, someone shouts out he has a knife, and Jimmy McGrath, 17 years old, tragically loses his life. He's stabbed to death, and now Raul Valle, he's on trial for his murder. And there are claims that it is a self-defense case. And Sarcasm brings out the point that, hey, you've got several people involved in a fight here. You've got the concepts of mutual combat. The idea that, there's also this concept of you cannot not invite the violence that you're then going to claim self-defense against. So you cannot be at a bar, throw the first punch, the other guy comes back at you and you shoot him and you say, well, that guy, I was defending myself. If you're inviting the fight, that you can't exactly then later on claim self-defense. Now, that's not entirely strictly true. If you start a fist fight and the guy brings out a knife, you're allowed to defend yourself in reciprocation. But with any self-defense case, it comes down to the concept of reasonableness. Did you have the defendant? Did the defendant have a reasonable belief in imminent danger? Did the defendant reasonably believe that the use of force was necessary? Did the defendant use a reasonable amount of force? It's all the reasonable standard. Whenever we're talking about the reasonable standard, we're talking about this concept in the law of a reasonable person in the defendant's shoes. So, in those same surrounding circumstances, given the same things that the defendant would understand, how would a reasonable person have acted? And if the reasonable person would not have acted as Raul did, then self-defense isn't going to prevail. Now, you could be talking about imperfect self-defense or other defenses, but self-defense itself as a outright defense, and self-defense is called a complete defense, meaning if the jurors find the self-defense to be true, then you walk. So if all of your actions, your perception, your belief, your response were all reasonable, you should walk. Yeah, K9 Lover talks about the Nikolai Mew case. Very similar. There was a fight broke out. He brings out a knife and he stabs somebody to death. So similar circumstances here. And interestingly, Nikolai Mew testified. Now, it didn't work out for him, but Sarcasm's question is, do they have to testify? Well, if your question is, are they required? The answer is, of course, no. A defendant is never required to testify. They have a constitutional right not to testify. But if your question is strategically, should they? Self-defense cases are unique in that I think that they are cases where more times than no, it might be a good idea for the defendant to testify, because we are talking about reasonableness in the defendant's shoes. Who is in a better position to explain the reasonable perception of immediate danger, the reasonable belief that force was necessary, the reasonable use of force, but the defendant? And so I also feel that in these cases where you are asking the jury to believe in self-defense, they might need to hear that plea from the defendant themselves. Look them square in the eye, say what happened, say this is a tragedy, say you never intended for this to happen, but you had to do what you did to defend your own life, and maybe you're going to give yourself a puncher's chance. But I don't think he's declared whether or not he will testify. Last I looked, he has not testified, but these are certainly those types of situations where you would expect to hear it, unless the defense has something else spectacular in their hands, or unless there's some other really compelling reason for him to not testify, i.e., he's been convicted of stabbing somebody in the past, and that will come out. So Thank you so much, Sarcasm. Appreciate you. Say hello to everybody in Fort Bragg for us, and we will keep it moving along here.
Hey, Josh, it's JC Broadway calling. I don't have a quiz this time, but I'm answering the call for courtroom dramas or movies, and could this really happen? So my movie is From the Hip from 1987, starring Judd Nelson, John Hurt, and Elizabeth Perkins. I was a whopping 16 years old, and I haven't seen it since then, I don't think. So if you do watch it and it doesn't hold up, don't judge me. But Judd Nelson plays a young defense attorney who's just starting out. He wins his first case, has big media attention, I think. He wins it kind of unethically, and he's pretty cocky. But because of that case, he gets a big murder essay trial. Enter John Hurt, and he realizes that he's guilty, and it's pretty heinous. And now he's got this moral, ethical dilemma, and decides to, no spoiler alert here, but it's been a while. If you haven't seen the movie, it's
Spoiler alert.
He decides to throw the case. He finds a way to make him crack while he takes the stand. So I'm just kind of wondering if you've ever known of anyone to sort of throw a case. All right, thanks, bye. Call me back.
JC Broadway from Salt Lake City, Utah. Thank you so much for sharing this with us. This is funny. Some dude's mom says, "Damn spoiled. I was watching that tonight." I figured that the 1987 comedic courtroom thriller From the Hip, starring Judd Nelson, would be on a lot of people's watch list. I did not watch this, JC Broadway. I wanted to, but I was exhausted. But we're going to show you guys the trailer, because you just cannot replace late 80s trailers. So here you go. Please enjoy.
Robin Stormy Weathers is gaining a reputation, the kind other attorneys spend entire careers trying to avoid.
I'm shocked. The limelight, the attention.
Love it. You just cannot replicate how great 80s films and 80s trailers were. It's just not the same anymore. So anyhow, I also imagine, first of all, everybody go check out From the Hip, and maybe we'll talk about it next time. I also imagine Judd Nelson in a week or two from now opening up his mail to look at his checks from residuals, and all of a sudden there's this weird spike in his 1987 magnum opus From the Hip. So put that on your playlist, everybody. I can tell even from the trailer that if I were to watch it with my attorney glasses on, I would be furious about all the things that would never take place. But thank you so much, JC Broadway, for bringing that classic to our attention. Appreciate you. All right. Oops. I think I gotta, did I do this right? Okay.
Hey y'all, it's Holly in Houston, Texas, calling in with 2 questions for Courtroom Confidential's most awesome Sir Josh Ritter. So without further delay, let's roll. Question 1 regarding Lisk. Now, I am watching a documentary on YouTube by the New Detectives saying that John Bittrolff, am I saying that right? Probably not. His defense attorney has filed mid-fall, I guess, whatever September is, if I remember the month right, that the crimes that John has been convicted of are, quote unquote, eerily similar to those of Rex Heuermann. So what do you think about that? My second question is about AI. I saw an audio evidence, whatever the word is. I'm just having issues right now. Sorry. They had redacted the 2 names of the little girls in that case. I don't recall the name of the case. So yeah, memory problems are a thing. Well, they used AI to add those names back in, and they did it in the voice of the people that were talking. And I'm like, wow, goodness night. So how can you trust what you actually hear in court? That was my initial thought. So what do you think about that? Okay. You guys take care. Bye.
Holly from Houston, Texas. Always good to hear from you. Thanks so much for calling in. A couple of really great questions. First of all, we're putting you on the map. Look at that map. Can we zoom out for a second? Look at that. Just Courtroom Confidential taking over the world. I love it. To your second question about AI and replicating people's voices, this stuff is wild. It is wild to me how much AI has advanced, even in the last few months, few weeks. I mean, it went from, I felt like a year or two ago, you could see something in AI and say, oh, that's AI. You would have that moment of perception where you would be like, this something about this, they call it the uncanny valley, where you just can understand something's not right, pick up on that. And I feel like you could do that with AI. You saw a video, you heard a voice, you would say to yourself, something about this is not right. I've seen AI stuff now. I cannot tell. And like fully generated AI, not just where they've taken somebody's face and made their mouth move, like fully generated AI stuff. It is getting to the point where we are going to have to start to think seriously about how we control this, because you're right. Things can be faked. Things can be absolutely fabricated. And how are we going to be able to tell reality from the AI? I don't know. We're, tune into my new podcast where I rant about our computer overlords taking over, but I have no idea the answer to these questions, but I know there are going to be serious legal ramifications from all of it. I'll tell you how I use AI. I'll tell you the advanced ways in which I use AI. First of all, friends of mine who are attorneys, it's to the point now where you can hand all your discovery, legal briefs, police reports into an AI machine and say, organize this for me and give me an opening statement, and it will spit you out gold. It is insane, the stuff that can be done now. Here's how I use AI. I sit there with my 2 little girls at night. We've got 3, but the baby isn't listening to bedtime stories just yet. I'll sit there with the 4-year-old and the 2-year-old, and I'll go, what kind of bedtime story do you want to hear tonight? And they'll say, we want it to be about princesses and a mermaid and a fairy who meet a dragon, and they help them solve the mystery of their missing gemstones. And I will dump all of that into Chat GPT. I will say, I want a bedtime story for a 4-year-old about 2 fairies named, 2 princesses named, Lola and Lily, and they wear pink and blue. Whatever you put it in, it pumps you out within seconds the best bedtime stories that you've ever seen. I feel like I need to drop my job and just get into writing children's books, because just incredible stuff, like full-fledged story arcs. If you ask it for riddles in the middle, it'll put in riddles. I mean, it's just incredible stuff. So that is as far as my advanced uses of AI at this point. Anyhow, to your other question, Holly, this is about the Rex Heuermann case and a person by the name of John Bittrolff. And will Rex Heuermann's case have any impact on his case? This is an interesting point. So originally, there was an investigation into 3 women who had disappeared between 93 and 94 in the Long Island area, and they had been discovered with very similar characteristics. They had been displayed their bodies in a very sexual manner. They all 3 had been missing one shoe, and wood shavings were found in the same location. Whether or not those wood shavings had anything to do with it is unclear, but there was 3 distinctly kind of similar characteristics to these women who had disappeared. 2 of them, Rita Tangretti and Colleen McNamee, were attributed to John Bittrolff, the person that you see here, and he was convicted for their murders. The 3rd person was Sandra Castilla, who has now been charged against Rex Heuermann. Now, the defense is saying, wait a second here. You're trying to, if they're similar, then you have to go on the assumption they were all committed by the same person. And if you're trying to say 2 of them are on this guy and 1 of them is on this guy, that's not the way this works. If Rex Heuermann was this active serial killer in the area, well, then maybe Rex Heuermann also killed Tangretti and McNamee and not our guy. And that is not an unsound argument. That is, if I'm those attorneys, I'm making those same arguments. There's, as with everything, there's a little more nuance to all of this. Obviously, all of the cases that Rex Heuermann has been charged with has been linked to him through DNA. In the Bittrolff case and the Tangretti case, they found DNA samples again, and those were linked to Bittroff's brother, not direct matches, but, you know, kind of familial DNA that then led them back to Bittrolff. But you could make an argument that these women were sex workers, and therefore the presence of DNA doesn't entirely implicate him as their murderer, only perhaps as someone who had been with them on an intimate level, and therefore he's not guilty of the murder. Anyhow, I don't know where the status of this is. It is an interesting argument. It is also interesting that maybe 2, perhaps multiple murderers had been operating in the same area against sex workers at the same time, dumping bodies in the same area. So really interesting point, Holly. Thank you for bringing up that question. I will continue to kind of follow developments on this, but as things stand right now, Bittrolff has been convicted for 2 murders, and Rex Heuermann is going to stand trial for 7 in the coming future here. We don't know when that is just yet. All right. Maybe I should have asked AI. AI might have had a better answer than I just provided. I'm going to just eventually substitute myself for AI, and you guys won't know the difference. Well, you'll know the difference because I'll sound a lot smarter, and you'll be like, this doesn't sound like Josh. Something's not right here. All right.
Hey, Joshua, Moz, crew, chat, guests, everybody. This is Alicia K. Mayo from Humboldt, Tennessee. Joshua, you know Courtroom Confidential is my favorite, and I don't have time to watch every YouTuber out there. So I did see something about Raul Valle from Connecticut, and I wanted to know more about the so-called preppy party murder, and I'm going to let you do that. Hope everybody has a great Sunday fun day. Thanks, y'all. Bye.
Thank you so much, Alicia K. Mayo from Humboldt, Tennessee, my spirit animal. I appreciate hearing from you. Let's put Humboldt back on the map. We talked about this already. You're saying Valle as well. Maybe I've got it all wrong. I gotta listen to this trial and see how they actually pronounce it. If anybody in the chat knows for sure, please let me know. But yeah, you know, we mentioned this case before. It's a really tragic case. Anytime a young person loses their life in the most ridiculous of circumstances, you've got a bunch of kids running around, having house parties, underage, drinking, fighting about beer, and now they're carrying knives on them. So just really, really horrible, awful stuff. And it's an ongoing case, and we will give you guys updates more on it as it goes along, but I don't have anything more for you, Alicia. Don't yell at me other than what I've already shared with you. So thank you again for your question. And we'll continue to watch that case.
Hi, you guys. It's Black Widow here in the Republic of Ireland. I want to ask you, do you know that great American lady, Sunny Jacobs, has passed away in tragic circumstances here in Connemara in Galway in the last, I think it was 2 weeks ago, in a house fire, which is terrible. And her carer also died in the fire. So rest in peace to the two of them. Long story short, I'm hoping Joshua will do his homework on it and bring the story to you. But it was in Florida, and Sunny and her 2 kids and her husband, I think their car broke down or something, and they accepted a lift off somebody. And whoever's car they were in was in an altercation with the police, and 2 police officers were murdered. And what happened from that was they were implicated in the murder, even though they had nothing to do with it whatsoever. Sunny spent, I think it was 17 years in prison, 5 of them on death row. And her poor husband was actually executed in the most botched, or one of the most botched executions in American history. It was really sick. Anyway, Sunny moved to Ireland and she met a man.
Thank you so much, Black Widow. I appreciate that question. Yes. So let's put Ireland on the map, first of all. Can't miss that. Sunny Jacobs. So you great job, because you gave us a lot of the facts and everything. And I'll just give you kind of the perspective from the prosecution as to why this woman was ever convicted in the first place. But you're right. We're talking about a case. There she is. She just recently passed tragically in a house fire. She had moved to Ireland and had been living there. Afton says you should see her art. She's so talented. She did become, in her later years, an advocate against the death penalty. She kind of became kind of a folk hero, and she died in a house fire in June. She was, kind of a media celebrity. They had done quite a few documentaries on her. 2020 did an episode. I think Barbara Walters interviewed her at one point. There was an off-Broadway play, kind of a folk hero, like I said. Well, the story goes, in 1976, her and her husband, her boyfriend, actually, Jesse Tafero, were in Florida. And I'm going to give you the briefest sketch of what took place, but they were at a rest stop in their vehicle along with another gentleman by the name of Walter Rhodes. The police approach to make contact with them. One thing leads to another, and both police officers are shot and killed. Now, it's unclear who shot. And I know that since that time, Sunny Jacobs has gone with the narrative that it was all a setup. Somebody else did it. She wasn't involved at all. But at the time, prosecutors said that she helped in the shooting. And there was some evidence about a taser being used, and perhaps she used the taser to subdue one of the officers while somebody else did the shooting. Her boyfriend was convicted, Jesse Tafero. She was convicted. Walter Rhodes, the other gentleman who was believed to have participated in the shooting, cooperated and flipped and testified against Tafero and Jacobs, and therefore that's probably why they both ended up in prison and initially on death row. He also confessed and recanted several times over the years. So the whole thing is just an absolute mess. But you're right, and I'm going to give a little bit of a warning here. I'm going to give you the details of Jesse Tafero's demise, but he was executed in 1990 in Florida in the electric chair, and this was a infamously botched execution that took several minutes before he actually met his end. And at one point, his head caught on fire. So it was really, really awful stuff. And then she served 5 years on death row. 17 years total in prison, and eventually her conviction was overturned because the appellate court felt that the prosecutors had improperly and illegally withheld evidence. And that wasn't, it was bad because it wasn't that it earned her a retrial. They said, you're done. You're out. This is convincing enough. That should not have been withheld. And you've been released from prison. Now, I will say, in the most technical of technicalities, that does not mean that there was not evidence against her. It's just that they felt that the flaw of not including that evidence was crucial enough that she shouldn't even be retried on it. So a pretty remarkable turn of events. And like I said, she went on to live a life that a lot of people admired. And apparently she was a very good artist. And she did just tragically die in a house fire. So thank you, Black Witter from Ireland, for bringing that case to our attention. I appreciate you, and I appreciate you calling in. And again, another case I was not all that aware of, but I'm glad that we talked about it. All right. Just a few more. We're at the home stretch, everybody. Stick with me. I'm enjoying this one. I'm enjoying this Sunday. We really have gotten a lot of very interesting cases that we don't get a chance to talk a lot about, and we're coming towards the end here. So last few of our messages.
Hey, Josh and Courtroom Confidential crew. It's Kathy in lovely Brunswick, New York. I don't have a legal question per se, but I thought it would be fun to start some silly legal trivia. So I'm starting you off with an easy one. In what state is it illegal to eat an orange in the bathtub? Looking forward to your answer. Later.
Kathy from Brunswick, New York. Thank you so much, Kathy. There you are. Or I thought I saw you earlier. Kathy, one of our mods, appreciates you and all your support and everything that you do for us. And now you're giving us quizzes. And I think I'm going to disappoint you because I did some research on this. I think the answer that you're looking for, Kathy, is California. And tell me if I'm wrong. But I did some deeper diving and I found out that this is not entirely true. Oh, you were going to say Alabama, Afton says. I saw somebody else said Florida. Good guess on Florida. I'm guessing California because that's what my research revealed, is that there was apparently some law in California that was misconstrued to be eating oranges in the bathtub. In any case, to test this out, I ate an orange in the bathtub, and so far, no red and blue flashing lights have showed up at the house. But I think where this came from is there was a law from way back ago in regards to food preparation in hotel rooms, and there was a law against allowing for people to operate kind of illegal kitchens out of hotel rooms. And that included the preparation and peeling of oranges done inside of the bathroom or the bathtub. And you can see where one thing kind of connected to another. And now you can't eat oranges in the bathtub. I think that's where it all came from. That's what my research revealed to me. But thank you, Kathy. That's a fantastic question. I appreciate you calling in on that. California is this. Oh, okay. What do I win, Kathy? You got to give out an award when you do a trivia. So thank you again for that. That was a great question. Had us all running to our keyboards to figure that one out. All right, let's keep it going here.
Hey, Josh. Joe Schmo from West Lafayette, Indiana, with another question about the Lori Daybell case and trials. On May 14th, right before her latest trial, she filed an oral appeal in court to have Judge Bareski recuse himself, and then a written motion on the 25th of May, and then Judge Green heard that and dismissed it. So she filed a motion to dismiss Judge Green and Judge Bareski and asking Judge Green to recuse herself. And those were all denied. But at what point in time does that become excessive? You know, there's the balance between the defendant's rights or a prisoner's rights, the court's rights, the rights of the public, the rights of the victims. I mean, our justice system involves the interests of all of those various parties clashing and creating conflict, and the conflict has to be sorted out through due process, and the court makes the final determination, you know, through that due process. But what is the court's ultimate power and authority to say that enough is enough? That the defendant's court filings have become excessive and we're going to cut it off. What power do they have to do that?
Joe Schmo, my friend from West Lafayette, Indiana, appreciate you support and appreciate the question. Lori Daybell, let's put you on the map there, first of all, before I get ahead of myself. West Lafayette, Indiana, appreciate that. Lori Daybell, yeah, she's a troublemaker. And she's just making everybody's life miserable. If she wasn't a horrible enough human being to begin with, now she just apparently just does not want to be forgotten. And so she did. She challenged everybody. She challenged the judge, and then she challenged the judge that ruled against her challenging the judge, and I'm sure she'll challenge everybody along the way. And Joe's question is, when does this become excessive? And I like the way that you put it. Like, listen, everybody's got a right to due process here. That is something that should not be forgotten. Due process applies to the defendant, but it also applies to the state. The state is entitled to things as well. The state is entitled to discovery. The state is entitled to a trial that's done in a timely manner. The state is entitled to many of the same things that are afforded to the defendant. And when does it become too much? When does it become excessive? Well, the answer is, unfortunately, kind of never. And here's the problem, is that you're dealing, your question is, can she be ordered not to challenge things? No. You cannot stop someone from filing ridiculous motions. You cannot stop someone from making ridiculous objections. Each one of those things is something they're entitled to do. Each one of those things, the law says you have a right to these things. It doesn't say you have a right to do them properly or a right to do them, to a certain extent. So the judges in this case are handling it exactly as they should. Handle them quickly, handle them properly. Don't waste time on them. But will a judge ever get to the point where he says, I'm shutting you down? I'm not allowing you to file motions. I'm not allowing you to make objections. I'm not allowing you to exercise your ability to represent yourself. No. And it's unfortunate, but it's not going to last forever, and we'll get through it. I'll tell you a story about, I had a case with this defense attorney who was just notorious for being litigious, and ridiculously so. And he was an attorney. And it was this constant bringing of motions and objections and sidebars, and just exhausting. And all of them failed. I mean, he was just, it's one thing when you've got somebody who's obstreperous, and another thing when they're also not all that bright. And he was that perfect storm combination, to the point that he had his laptop in court and a portable printer. And he would be sitting in court, and if he didn't like what was going down, you would see him typing away, and then you would hear the printer, and you knew that he was filing another motion to the court about objecting to something. It was so ridiculous. And it was like, we were like Pavlov's dog when we would start to hear that printer going off, that the headache would immediately swell up in your head, because here he goes again. And he'd sit over there and print off his several copies and staple it all and file it with the court in the middle of trial, in the middle of court proceedings. These things would be taking place. but the judge can't shut him down. Can't say I'm disallowing you to make objections and file motions. Judge can just say, okay, denied, moving on. And that's the way it's handled. And that's, that's part of our system, is that people are allowed to make their objections, and nowhere in there does it say you have to be a good attorney. It says you can represent yourself. It doesn't say you have to do a good job. So thank you, Joe Schmo. But believe me, every day has its end, and pretty soon we're not going to be talking about Lori Daybell, pardon me, all that much anymore. All right. Who's going to bring us home, folks?
Here's a little song in fact for Josh, Tiff, Caitlin, and the chat, but don't worry, be happy. Josh will always tell us what we need to know. That will make our whole day glow. Don't worry, be happy. Well, so of course I always have to sing along, but I do have a question, and the question is, Josh, what are your thoughts about the expansion of social media in the true crime arena? Back in the day, trials were not televised, there was no internet. So I'm curious how your colleagues and your judges and the legal eagles and the legal arena in general feel about the court of public opinion and the exposure and explosion of social media. So that's my question, and everybody have a great Sunday, and it's the best chat on all of true crime.
Oh, Jodie, you are such a treasure, and you warm my heart, and I love that. I love that song, and I appreciate you so much. That was fantastic. I think everybody, round of applause for Jodie. It's one thing to leave a question, another to perform it. So I appreciate you. And you ask a great question. I love this question. How is the advancement in social media and the advancement in just media coverage in general? Oh, thank you, JC Broadway. What has it done to courts and trials and the true crime world and everything else? I love this question, mainly because I'm at the intersection of those things. I still operate as an attorney, and I'm involved in this kind of media world as well. And I think about this question a lot. And I think the answer to it is, I think it's both good and bad. I think it's a net positive, but I think it's hard to say that there's not negative consequences as well. I think it all depends too on where you're consuming that media coverage. If you're doing it from a reputable journalistic source, that's one thing. YouTube channels, obviously, I think they run the gamut between good and bad, and intellectual honesty and some not so much. I'll let you all make your own decisions on where certain things fall. I think Twitter is also or X is also its own animal. I mean, it was funny to me. I think the Karen Reed case was an excellent example of that convergence of the media, social media, and trials. Here's a case. Just think about this. Karen Reed was a person probably unknown other than her tiny world of friends and family. She's a professor in Massachusetts. John O'Keefe, unknown probably outside of the world of his friends and family and coworkers. And he's killed. And he's a Boston police officer. And police officers are always going to get, the death of a police officer is always going to get some attention, but usually locally. How in the world does that case become a nationally covered case? How is that become a case that Dateline and other outlets are doing docuseries and follow-up interviews on? How has that become a household name? It's fascinating to me. And I think you could point to a lot of different things. I think you could talk about the media coverage of it kind of perpetuating. You could talk about certain bloggers who made a name for themselves during that whole thing. You could talk about the defense team was so good that it drew a lot of attention. And what always fascinated to me about that case is if there was a day in court you didn't watch and you went on Twitter and tried to figure out how it went, you had no idea, because depending on who you were reading, it either was the best day on earth for the defense that a defense has ever seen, and this woman will be exonerated and elected president, or it was the most devastating day for the defense ever known to man, and this woman is probably going to be convicted of murder and the murder of several other people. It was like so divergent and polarized and ridiculous on both ends. And it was remarkable to me, and I think a symptom of the media coverage, but just also a symptom of kind of media in general, and just the ability for people to have access to large groups of people. I mean, it's amazing to me that here I am sitting at my little desk in front of my computer, and this is something that's being broadcast to the entire world. That's amazing to me, that we have people asking questions from all over the world. That's amazing to me, and something that not too long ago was impossible. The idea of it was absolutely impossible. If you wanted to broadcast to the entire world, you had to have a huge corporation and TV access and everything else. And now, literally, you could use your phone if you want the entire world watching. So we live in pretty incredible times. And I don't know if I have a conclusion, a wrap it up point to all of that, but I do think obviously more transparency is better. More coverage is better. Giving people an insight as to how justice is done is always better, but there's going to be some rough around the edges fallback from all of that, like there is in anything in life. But Jodie, one thing I do know, Jodie, is that you are fantastic, and that song of yours is fantastic, and I appreciate you for asking the question. So thank you all. All right, that was it. Let's get to some announcements, and then we got our big winner to announce. So first of all, if you missed it, yesterday we released our weekly roundup. If you guys are new to this channel and just finding us now, please check out our weekly roundup that we do every week, where we talk about all the cases that you may have missed throughout the week. We talked about Karen Reed and Bryan Kohberger and Sean Combs and Rex Heuermann, all of the cases that you've been following. So please check that out. That's up on our channel now. Monday, we're going to go live again at 5 p.m. Pacific, 8 p.m. Eastern. That's just tomorrow. We're going to have Lauren from Hidden True Crime as our special guest. We're going to be talking about the latest developments in the Suzanne Morphew case, and that her husband has now been indicted once again for her murder. And what's the latest on that? It's a case that has been around for years. He was indicted, then the case was dismissed. Now he's been indicted again. What new developments have taken place? And why do we find ourselves where we are now? That's Monday. Wednesday, we will have our Wednesday night live. Again, 5 p.m. Pacific, 8 p.m. Eastern. And our special guest is going to be Scott from Recovery Addict. Always love Scott. If you're watching live trials anywhere and it's not Courtroom Confidential, you should be watching them with Scott. He does a fantastic job. So he's a good friend of ours as well. We are going to have him on on Wednesday, 5 p.m. Pacific, 8 p.m. Eastern, on topics to be determined. I think we just might check in on a few cases on what's going on. So check that out this Wednesday. And then finally, as always, our live trials channel is not going anywhere. We're just waiting for the next trial to come up. So let us know what you guys are most interested in. We talked a little bit about James Craig. We talked a little bit about Bryan Kohberger. Both of those cases coming up for trial soon. And both of those cases, coincidentally, we have done case notes episodes on. So please check that out in our playlist under case notes. We did a deep dive on James Craig and a deep dive on Bryan Kohberger. And you guys, we got a lot of great feedback from both of those. So please check those out. And let us know which trial you want us to follow live coming up soon here. All right. Last few things. Membership. Where do I go to find our membership? How do I do this, Kaylin? There we go. You go to thecourtroomconfidential.com. There we go. There we go. Do go to thecourtroomconfidential.com, click on become a member. We work a lot on making sure that the membership program is something that you guys want to be a part of. So if you have been thinking about it, please check it out. Please join, become a member, and find out all the benefits. You can do that on thecourtroomconfidential.com and click on this button, become a member. How do I leave you a message for next time so it will be answered? You go on, send a voice message here on thecourtroomconfidential.com and record a message, and we will read that next Sunday. And then finally, you can always check out our shop where we have all of the merch, including, what am I wearing today, Tiff? This is one of our brand new Courtroom Confidential t-shirts with the logo rather than the, I don't know what you want to call it, our alternate logo. And what color am I wearing? Tiffany's going to let us know in a minute. That's also on thecourtroomconfidential.com if you click on the shop button. All right. Should we do this? Should we announce our winner? Drum roll, please. Oh, it's khaki, says Kaylin. Khaki? That's not very inventive. Of all the names, they came up with khaki for this one. Well, I like it. It's a good one. All right. Drum roll, please. The winner for our 35,000 subscriber giveaway, randomly chosen from somebody who left us a message this week. I'm getting a big hold on from Kaylin. The anticipation is killing us, Kaylin. Show us. Who's our winner? Flora Paris. Flora Paris, you are a big winner. Thank you so much for asking a question. Thank you so much for leaving a comment. Flora, you're fantastic. And you will be getting a Courtroom Confidential t-shirt in the size and color of your choosing. And if you like khaki, this is what it looks like. But we have all of the colors online as well. Flora Paris, big shout out. Big congratulations to you. And thank you for the question this week. All right. To our mods, Afton and Sonia and Kathy, you guys are all fantastic. Thank you for all your help, both on this channel and on the live trials channel. And I wanted to give a special shout out and thank you to Kaylin's dad this week, because I had, Kaylin was over at the house helping us out with some stuff, and I drove up with my truck, who, by the way, I still got a great deal on, and I had some heavy stuff in the back, and he was kind enough, he had been there to pick up Kaylin. He was kind enough to jump out of his car and come help me carry the heavy stuff. And I thought, what a gentleman, what an example. And so I wanted to give a special thank you to him, Kaylin's dad, everybody, for being a great guy. Thank you all for being here. Thank you for spending part of your Sunday for us. Thank you for 35,000 subscribers. Have a great weekend, everybody. And we will see you again shortly. Take care.